no further ado, Jonathan, let me just say a word about him. He is a recent doctoral student. He completed his doctoral degree here at the University of Missouri School of Journalism. Just last year, wrote a brilliant dissertation that we can talk about offline, but it had nothing to do with this topic. He actually has a passion, having worked with Kathy Arberg at the U.S. Supreme Court in public information offices, learned a lot about that, and is working on a piece about this right now.
Absolutely. Thank you, Richard. Thanks for all of you for coming and for sticking around. One of the things about being a PhD from Missouri is it's kind of terrifying to be in this room right now because two members of my dissertation committee are here. And so I'm fully expecting that afterward they're going to send me off to Caldy's as they always did and make me do revisions to all my remarks. So I'm just blessed to be here. As Richard mentioned, we're actually cheating a little bit on this panel where what I'm going to be discussing is the history and role of the Public Information Office at the U.S. Supreme Court. And for brevity's sake, I will focus on the PIO's early history. My article for the symposium issue will be much more comprehensive, but with the time constraints here, I just want to hit some of the highlights. My starting point is going to be to reiterate one thing that both David and Beth mentioned, that the press is the primary link between judges and the public, and the PIO is the primary link between judges and the press. So at the Supreme Court, the PIO staff, right now 5 employees, is responsible for credentialing reporters, fielding requests to shoot video in and around the building, answering questions from the press and public about court traditions and procedures, and advising the justices on press matters, among many, many other things. PIO staffers wear a number of hats, and so that you've got a more concrete sense of exactly how they wear them, I'll walk you through one case. In 2006, Anna Nicole Smith drew a large crowd when she was at the U.S. Supreme Court. The former Playboy model and reality TV star, she was there to watch oral argument in her own case. It was a probate dispute that was attempting to claim part of her late husband's estate. Photographers swarmed her. One bystander, as she tried to enter the building, shouted at her that she's a goddess. The public line to attend the argument wrapped all the way around the plaza. And as the writer and law professor Jonathan Turley noted, Smith's appearance generated more news coverage than it would if Chief Justice John Marshall returned from the dead for the argument. Once in the courtroom, Smith blended in. She was just one more face, barely perceptible amid the 300-some people in the room. It appeared that few in the gallery even knew she was there, sitting about midway back in the public section and wiping away tears as Justice Breyer talked about her late husband, who was a billionaire oil man who married Smith when she was 26 and he was 89. So one of those charming love stories. And so at the center of this media frenzy was the Public Information Office. It credentialed reporters to attend the argument, it fielded requests from broadcasters to shoot video around the plaza, and it answered a lot of questions about court traditions because many of the journalists covering the case had never covered the U.S. Supreme Court before. At the same time, the PIO did not release any news releases, media advisories. There was no press conference. And the day after the argument, a college intern in the Public Information Office asked Kathy Arberg about the office's origins. Kathy Arberg was then and is today the court's public information officer. And the intern basically wanted to know where did the office come from and historically how did it operate. Kathy didn't have a clue, and nobody else in the office did. The general consensus seemed to be that in the 1930s, an Associated Press reporter misinterpreted the opinion in the Gold Clause cases and sent out a bulletin misstating the court's decision, which was an error that facilitated the hiring of a press liaison and the creation of the Public Information Office. In reality, the story of the PIO is a lot more complicated than that. In the 1930s, the court found itself in the middle of Great Depression policymaking. Franklin Roosevelt was lobbying Congress to pass elements of the New Deal to improve economic conditions around the country, and many of the bills passed, but as you know, the Supreme Court did strike down quite a few of them. He was determined to get around the court, so what he did was push for the Judicial Reform Act Bill of 1937, better known as the Court Packing Plan. Among other things, it granted the president the authority to appoint up to 6 additional justices to the court. which would be one new member for every sitting justice who is at least 70 and a half years old. Roosevelt thought that by expanding the size of the court, he could create a pro-New Deal majority. The plan failed, but the court's independence had been threatened. And so what the court did, they felt compelled to fight back and to try to manage the court's image. So Chief Justice Charles Evans Hughes, by way of example, he wrote a letter to the Senate Judiciary Committee challenging Roosevelt's rationale behind the court packing plan. The letter was published in a number of newspapers. Around the same time, the court quietly appointed a member of the clerk's staff to handle requests from journalists who were interested in what was going on at the court. The idea came from a committee of reporters that pitched the idea to Chief Justice Hughes, and the job ultimately fell to a man named Ned Potter. He had worked in the clerk's office recording the court's formal minutes. That is it. He had no journalism experience, he had no public relations experience, and no other administrative experience. And I think that that was the point. Court officials emphasized at the time that Potter was not a press agent, he was not a PR counselor, he would issue no handouts, no press releases, no media advisors. He would not comment on opinions, he would not interpret opinions. He would simply maintain a complete set of briefs for the convenience of the press. He would credential reporters for courtroom seating, and he would supervise the physical space of the press room. So this marked a major, major step for the U.S. Supreme Court because it institutionalized for the first time the Supreme Court's press relations. At the same time, though, it did not even merit an official announcement from the court. There was no press release, no memo, nothing. Potter's appointment became known only when he moved his desk and his filing cases from the clerk's office to a different room. And that other room was the new press room inside the Supreme Court's new building. The rooms included, they were pneumatic tubes that linked the press room and courtroom upstairs and enabled reporters upstairs to send copy down below to telegraph and telephone instruments so that their reports could be carried out more swiftly. Potter's tenure was largely unremarkable as a public information officer because he basically shuffled paper. He stepped down in 1947 to be replaced by a man named Burt Whittington. Whittington had covered the court for a number of years for the United Press. He carried on the clerical task of maintaining briefs, credentialing reporters, and supervising the physical space. In a conversation that I had 2 years ago with Tony Lewis about Burt Whittington, Tony gave me this quote about Burt. He said, "Whittington never performed public information functions as most would understand them. He simply handed out opinions and did clerical things. I don't mean to be unkind when I say he was just that, a clerk. The justices did not want more." Still, I would add that in his 26-year tenure, Whittington did far more than Potter ever did to take on the role of press counselor to the justices and advocate for the press corps. I'll give you 3 examples here. So first, to keep the justices informed of news coverage of the court, Whittington began sending memos to chambers that included news clippings. He maintained a list of reporters covering the court, and when a new reporter joined the beat, he would send up a memo to the justices to notify them. Second, Whittington produced an in-house newsletter called the Docket Sheet. It was distributed to all court employees, including the justices. And it included all manner of personnel news. So it was, hirings, babies, retirements, and so on. And then third, Whittington conferred with the justices about news coverage of their speeches and opinions, sometimes advising them on why an opinion or a speech failed to generate news. Meanwhile, as an advocate for the press corps, Whittington pushed for changes to court practices designed to accommodate press needs. And one was the release of opinions at the end of the term. For many years, the court released opinions only on Monday, and the big ones stacked up as the term progressed. So this is something that I'm sure Adam can relate to. As a result, the justices often released a dozen opinions totaling hundreds and hundreds of pages on a single day in June. That really frustrated reporters who found it difficult to wade through the opinions and report on them accurately. All on a deadline. So in 1965, with intense lobbying efforts by Whittington, the court changed its practice of releasing opinions only on Monday. 1 year later, Whittington lobbied the court, specifically lobbied Chief Justice Earl Warren to release headnotes with every opinion. Some justices already did so, but most did not. And clerks prepared the headnotes most often when the opinions were on their way to the U.S. reports. This was well after the opinions were released. Whittington was unable to persuade Warren to go along with his idea, but he had better luck a few years later with Chief Justice Warren Burger. NBC reporter Carl Stern first brought the idea to Berger. This was at a cocktail party where Stern approached Berger and told him a story of how he reported a case wrong on a day the justices dumped a dozen opinions. Stern promised it would never happen again if the court would begin using headnotes. Whittington supported Stern, and Berger instructed the reporter of decisions to make it happen. So with the wind at his back, what Whittington did next, he worked with Berger to enlarge the courtroom's press section. For years, the press sat directly in front of the justices. And unfortunately, that sub accommodated only about maybe 5 or 6 reporters. What Whittington wanted to do was to move the press gallery to the left of the room, which would quadruple its size, and give Whittington basically an overflow area behind the seating. And it was really much needed because at the time, the number of legal affairs reporters was on the rise, led by the likes of Tony Lewis. And the reporters said that there was only one problem with moving the press corps to the left, that where they sat in the front, they would no longer be able to hear the justices whispering to one another on the bench and use that in their reports. By the early 1970s, America was at war abroad and with itself. You had fighting, raging in Vietnam. The Pentagon Papers ignited a debate about national security and free speech. Woodward and Bernstein were unraveling the Watergate scandal. Abortion restrictions divided the country. All of these issues reached the court in one form or the other, where Berger had been chief since 1969. He was an energetic and imposing man. And he presided over a court that, in its own way, was as activist as Earl Warren's, creating new doctrine in areas like the right to privacy, due process, and sexual equality. Along the way, Berger did all that he could to preserve the institution's secrecy and to keep secret the court's internal operations. He was also frequently hostile to the press. Asked by a lawyer once what he thought of reporters covering the court, Berger replied, as he often did, quote, "I admire those who do a good job, and I have sympathy for the rest who are in the majority," end quote. Berger reserved special scorn for TV, which he regarded as deeply intrusive. He said in 1979 that his constitutional right to privacy entitled him to refuse to admit broadcast equipment to any of his public speeches. Ironically, Berger was a former newspaper man. He was a newspaper freelancer, and he wrote several of the court's most important opinions interpreting the speech and press clauses. He also held regular meetings with the court called Wages and Hours sessions, where Berger discussed with reporters the conditions and press policies at the court. These were intended to be informal and off the record, but comments would very often escape. At one of them, when the court was renovating a number of rooms, a reporter asked the chief, "Would you like us to pay rent?" Berger paused before responding, "No, because renters have rights." Joking or not, Lyle Denniston, who has covered the Supreme Court for 60 years, told me last summer that he thought that was reflective of Berger's general attitude toward the press. In any case, Berger gave his most sustained attention to judicial administration. He created offices and institutions whose purpose was to improve the efficiency of the judicial process. And at the Supreme Court, one of the areas that caught Berger's attention was press and public affairs. And Whittington retired in 1973, and rather than simply appoint someone to replace him, Berger created a whole new office, the Public Information Office, to be led by a public information officer. For the new position, Berger wanted a reporter who understood the news world and not one trained in the law. A lawyer might be tempted to comment on opinions, and those comments might be taken as controlling law. Berger also wanted somebody who had served for 5 years as a government spokesperson. Somebody who understood what State Department spokesman Bob McCloskey once said, which is reporters and spokesmen have the same task, to explain what the government is trying to do. The spokesman has an additional task, to help the government succeed. Barrett McGurn ended up getting the job, and he beat out 140 other applicants for the job. He became the court's first formal public information officer. He had 3 decades of journalism experience as a reporter for Yank magazine and former chief of the Rome, Paris, and Moscow bureaus of the New York Herald Tribune. After leaving journalism, McGurn was the press attaché of the U.S. Embassy in Rome, the embassy counselor for press affairs in Saigon, and the deputy spokesman for the State Department. McGurn was a formal man and conceived of the PIO as a place where reporters could get documentary materials and courtroom seating, but not much else. Consider these comments, all of them shared with me a year ago when when I was conducting interviews for this piece. This one from Steve Wormiel, who covered the court for the Wall Street Journal. McGurn was useless and contemptuous of the press. He thought that the beat was all about handing out opinions and providing the orders list. From Lyle Dennison, who covers the court for SCOTUS blog. You would have to break McGurn's arm to get him to do anything because he did not care about the press. From Tony Morrow, who covers the court for the National Law Journal. His office was not helpful at all. He was really tough to work with. And from Dick Corelli, who covered the court for the Associated Press, McGurn was the palace guard. McGurn's role was to preserve secrecy and insulate the justices. When a reporter requested an interview with a justice, McGurn often did not forward the request to the justice. When he did, he would attach a memo presuming that the justice would decline the interview request. Of all of the memos that I dug up in various papers of the justices, the line that appeared most often was, shall I tell the reporter you decline? And so McGurn might have done so because of the individual press practices of the justices. Few do grant interviews, but his presumption certainly made it easy for them to decline. When a reporter asked McGurn for information, he rarely provided it. This despite what he called the PIO theory, that there was no such thing as an indiscreet question, only an indiscreet answer. But in 1978, the columnist Jack Anderson was able to characterize McGurn's attitude toward the press, and saying that he is a faithful reflection of his master's view that the press should be given only what Berger believes they should have. He went on to explain exactly how McGurn would dodge questions. This is from Jack Anderson. It's a form of Nixonian stonewall. Instead of refusing comment, he answers a different question, as if he had not understood the one actually asking. One reporter, thinking McGurn did not hear him, kept repeating the same question. The press officer, like a telephone recording, repeated his irrelevant, unresponsive reply. As another victim of McGurn put it, your first impression is they're putting you on. Your second impression is they're insulting your intelligence. Linda Greenhouse, who covered the court for 30 years for the New York Times, told me that McGurn often did more than deflect. He plainly refused to answer questions, and for no apparent reason. In the early 1980s, she was standing in the PIO's outer office when the phone rang. On the other end was a person asking for information about the status of a pending case. McGurn said that was a question better put to the clerk's office rather than the PIO, and the person asked for the clerk's office phone number, only to be told by McGurn that it is a non-public number. Of course, it's no such thing. You could look it up in the DC phone book, and it's right there. But McGurn had this hardwired instinct not to share any information under any circumstances. And in general, too, reporters felt that they had to be circumspect around him because he was to Berger what wiretaps were to Nixon. The press corps suspected that McGurn was relaying conversations that he would overhear in the press gallery or in the press room. And the suspicion was so strong that veterans of the court beat would warn newcomers that you need to be careful around McGurn because anything you say around him can be relayed to the Chief Justice. Their suspicions were well founded because what I found in Justice Thurgood Marshall's papers were memos from McGurn to Berger describing conversations that they had had. For his part, McGurn dismissed the need to be circumspect and said the court was not secret. He said it operated in a goldfish bowl. That was the case because briefs were public, oral argument was public, and the justices set out their reasoning and opinions. Whether that makes the court public or not, I have no idea. But for a while, when reporters retired or otherwise left the beat, they were given a gift by their colleagues, and that gift was a goldfish bowl. So I'm running out of time here, but I'll close with a confession and a final comment. I mentioned that the day after the Anna Nicole Smith argument, a college intern from PIO asked his boss about the office's origins. That intern was me. And I've had an interest since then in the PIO's history and role, and I believe it's worthy of study because the interaction among elites and the public is of such critical importance in democratic society. To explore the PIO's history is to explore how the court has attempted to influence the flow of information about the court and the rule of law. Democratic institutions are founded to serve their citizens. That flow is highly important. In theory, as Dave and Beth mentioned, the justices are insulated from the public. They need not gauge public opinion on a day-to-day basis, but the court's power is preserved in part by public opinion. So it does matter what the public knows about the institution and how the public feels about the institution. Research on attitudes toward the court reveals a shallow reservoir of knowledge about the Supreme Court. And yet the court tends to be the most popular institution of the three branches. That may be because it speaks as a unit and its decision-making process is less noisy. That may be because the justices seldom comment extrajudicially on factious issues, or that may be because of the so-called cult of the rope. Whatever the reason, the force of judicial opinions, it depends on a fragile constitutional chemistry. And that force is preserved in part by the PIO. The justices cannot disseminate their work product widely. So they rely on the PIO and on third parties to help them. Put another way, as Justice Breyer said in 2011, the court's legitimacy is, quote, enhanced by allowing the public to see the justices as committed, careful, and apolitical. Working with and through the press may be necessary to convey that message. And I would just add that working with and through the PIO may be necessary too. Its history is the story of connecting justices and journalists, in theory, to establish and maintain mutual understanding and cooperation, and in practice, to increase or restrict the flow of information about the court. Thank you.
Welcome now Ben Holden. He is a journalism professor in Nevada and is the executive director of the Media and the Courts program of the National Judicial College, which is based in Reno. He's going to, in my broad conception of press freedom, talk about press freedom, comparatively speaking, here and in the Kosovo. Thank you, Ben.
Okay. All right, it's a little bright in here for a seance, so you're going to have to close your eyes and pretend that you're in another place at another time, perhaps an Alcoholics Anonymous meeting. And I am going to be the speaker. I'm going to go first. I'm going to begin with, my name is Ben, and I'm a lawyer. What's worse, I married one. The interesting thing about my background and the context that I come to you in that sort of informs my remarks is I went to J school here at the University of Missouri, and the most influential person here for me was a guy named Dale Spencer, who you guys might know. I took Dale's communications law course in 1984, and it had such a profound impact on me that I immediately decided to go to law school, much to the chagrin of the folks from the Post-Dispatch who paid my way through Missouri. So just by way of context, I want to speak for a few minutes about the context. They didn't make me pay the money back either. The context of the U.S. relationship with the nation of Kosovo. If you are in Russia or in China, there is no nation of Kosovo. 55 nations recognize it. Many are neutral and many do not. Russia and China say Kosovo is lower Serbia. So it's sort of hard doing courts and media consulting for a country that doesn't exist, as my friend and colleague Ron Kiefover and I learned firsthand when I made my second trip over there Thanksgiving Day, missing 2 really perfectly good football games. So the context is as follows, kind of like the Jamaicans and the old Living Color show. I've got about 4 jobs. I'm a lawyer and I'm a journalist, and getting back to David's point about Judge Clay Land. Judge Land is a good friend and colleague. My wife practices before him frequently in Columbus, Georgia. And we had a very long talk about Chuck Williams tweeting from his courtroom. Chuck worked for me for many years when I was in Columbus as the editor. And in fact, Judge Land is very adamant in pointing out that he had the exact same tweeting issue more recently, about a year ago. And in fact, Chuck wrote about it. Judge Land has reversed his view, not in writing, but he allowed the Ledger Inquirer and let Chuck tweet from his courtroom within the last 9 months. And he initially wrote a very short unpublished opinion about tweeting from the courtroom, where he looked at the traditional federal definition of broadcasting. To broadcast is actually kind of a farmer term. To broadcast is to disperse. And he analogized, because there was no definition to be used for tweeting, he analogized dispersion from a broadcast or TV camera as being indistinguishable from tweeting from a device like this one. And he came to a conclusion that many of us, and I very respectfully told him I thought he was wrong, many of us thought was mistaken. So at least in Columbus, Georgia, in the Middle District of Georgia, if you come before Judge Land, you can tweet so long as he doesn't have some other reason to tell you not to. And by the way, another shameless plug, I wrote a letter about that to the readers in the Reynolds Courts and Media Law Journal, which you can subscribe to if you like. And for only 13 bucks, you can have a copy of that. All right, Kosovo. There's something called the Organization for Security and Cooperation in Europe, OSCE, big fancy word. It's 50 some odd nations. They put a bunch of money in the pot, and they do nation building, not just in Europe, but in other places. They decided, for some foolish reason, to hire me in one of my 15 jobs to go over there for much of the summer in July through August of 2013 to put together a courts and media compendium, essentially a reference guide for journalists. The coverage of the courts by journalists in this nation that did not exist for anyone until 2008, when in the aftermath of the Serbian war with the Kosovars, where Bill Clinton in '99 sent our air reforces over there and bombed the Serbian army and essentially created this nation. So they are essentially a country that's about 5 years old, 2008. They created most of their law based on advice from lawyers in the U.S. State Department, and that's who financed the trip for Ron and I the second time. The French and Jean-Claude Chalombier, who's the head of OSCE, are very, very big in nation building, as are the Germans. Their law, therefore, looks a lot like ours, but with some really odd differences, and I'm going to sort of run through a couple of those differences. Some of them are technical and written, and some of them are just sort of relationship-based in terms of how the courts view the press and vice versa. The first thing I'd like to point out about Kosovo versus the U.S. is there are many similarities, and I'll get into some detail in a moment. But Judge Wolf mentioned law speakers. There are, in fact, not just law speakers in Kosovo, as some would argue here in the United States, but there are also news speakers on the other side. In other words, at the Judicial College, when I go in Reno and talk to groups of judges, maybe 100 at a time, who have just joined the bench, frequently they tell me all kinds of urban legend about journalists and the way they behave. I mean, it's funny stuff. It's remarkably biased and remarkably inaccurate about how people like Howard, who are in the business of doing journalism, really have these agendas, and how we almost have these meetings to decide how to oppress the judiciary. I mean, if there are any judges who see this tape, I don't mean you, Your Honor, I mean the other judges. So, in fact, in Kosovo, the judges as a group, and not unlike some of the judges here, the judges as a group have this view that the journalists are really, really biased, and that they are in fact pushing these agendas. And when I met with 30 or so journalists and 30 or so judges over a month, here were the conclusions, the speaking, the news speak from the judges. Number one, they said as a group, journalists are biased against the judiciary, and they have this special bias. In Kosovo, unlike in the United States, the least popular branch of government is the judiciary. They do these surveys every year, and the most popular branch is the police, believe it or not. Kosovo is about 80–85% Albanian, ethnic Albanian, and about 10% Serbian. The Serbs in Mitrovica actually took over the courthouse and after the war, and in fact, the courthouse in Mitrovica is not used. If you're the chief basic judge of Mitrovica, your court sits in Vustri, another city to the south. So the judges are very, very, very unpopular, and they blame the press. They say that journalists are sloppy and poorly educated on the law, and that actually is a fair criticism, and that's in part why they brought Ron and I over. Ron to train the PIOs and me to do some work with the journalists. They say that there are no sanctions for press errors, which I find particularly ironic, because in Kosovo, unlike in the United States, naming a confidential witness in a newspaper is a crime. It's a crime. And Ron will tell you, when we had our second conference over there, where Ron was doing a bunch of training, there was actual discussions with straight faces from prosecutors about let's get serious about putting folks in jail when they disclose the names of confidential witnesses. Now, it's a little different than here. I mean, it's not like the mafia, but you in fact have people who were revolutionaries who are now politicians who committed alleged war crimes. And there was a guy who was on trial recently, their number 2 guy in the army, and the primary witness in the case was found hanging from a tree in Germany a year ago. So it's high-stakes poker. It's not a game if you put someone's name in the paper who is a confidential witness. But at the same time, they do not have the same separation between civil and criminal sanctions for press errors. Lucy Douglas, who many of you know as the former head of the Reporters Committee, said to me in the context of the courts and media work that your main goal, my main goal and my main job with the Reynolds Center is getting judges and journalists in a room together. That if you do that, you've kind of come pretty close to winning the game. And that is how I approached the work in Reno and how I approached the work in Kosovo. But it was not really, it wasn't really easy because unlike here, there is not the veneer of civility there. I mean, judges, in fact, unlike Judge Wolf or anyone that he would know, there is a level of corruption in a new country like that that would really, if I had any hair, it would curl it. It's amazing. And so when there's a high-profile corruption issue, the journalists extrapolate and they think all judges are corrupt. And they'll say it out loud at a conference like this. And hence the judges have this open contempt for the journalists. And it can be a little rough. We actually, at the conference we had on the 15th, not the one with Ron, we actually had a journalist interview a judge with an iPhone out in a lobby, just like this, at a conference, and record something the judge said that was very unkind, twist it, and blogged it and posted it that day, which I don't think would ever happen here. I mean, no responsible journalist in America would do that, and that was actually done by the Balkan Investigative Reporting Network, which is their strongest media outlet in the entire nation of Kosovo. They are kind of the Washington Post meets the National Enquirer. They have big resources and big ambition, but they have a low level of objectivity and accuracy. What I said at that conference and what I'll say here, which is to me the watchword of all of the work of trying to bring any group of judges and journalists together, is a quote from Edward R. Murrow. What distinguishes a truly free society from all others is an independent judiciary and a free press. That's actually on our website, and I firmly believe that, and I want to do a quick list, and you'll get much more detail if you look at the article that I'm preparing for the Missouri Law Review, but a quick list of things that are kind of different about Kosovo, some are the same, but I think these are the tenets that make a true free press democracy. I'm sort of making up a phrase there. A democracy that, you know, putting aside its other tenets of government, that makes it a place where the judiciary is real and independent and the news media is credible. Number one, healthy societies empower their news media to make mistakes. It's the 50th anniversary of the New York Times Sullivan. I was actually talking for the Dr. King holiday at a little church in Reno, and I did an entire talk about New York Times versus Sullivan as sort of this civil rights accident. And those of you who know realize that there were several lawsuits, Adam, I'm sure knows this, against the New York Times in 1962 and in 60, and they'd already lost one of them. And in fact, they're at the risk of quoting Hillary Clinton, there was a vast right-wing conspiracy to take out the civil rights movement via litigation. And had New York Times Sullivan gone a different way, many of those lawsuits would have been lost and many of the Court of Appeal decisions would have been upheld, and we'd have a different, arguably a different face of civil rights. So free societies allow their news media to make mistakes. Of course, the lawyers and the journalists know, and the law students, that the New York Times standard of actual malice, of knowing falsity or reckless disregard, where you can in fact make a mistake, you can be careless in writing about a public figure and still have a shield that is the First Amendment that protects you from liability. That is a strange idea in many societies, and it is something that I think makes our system incredibly strong. There is the context in Kosovo of seditious libel. And of course, in 1798, our former President John Adams passed or pushed through the Congress the Alien and Sedition Acts. They got rid of seditious libel about 2 years ago. The idea that you could be criminally punished for criticizing the government to a society like ours just seems nuts. But they just got over that hump in the last 2 years. The second point is transparency. So the first is empowering the media to make mistakes. The second is transparency. They wrote into their constitution, or at least the consultants did, Article 22, where they incorporate these international free press standards. Not only does the court, not only does the executive branch, not only does the legislative branch have to allow you to get open records and and have open documents, it's in their constitution, which is a huge step. And we have the First Amendment, but it doesn't say documents. So they have, at least on the surface, taken this huge step. The problem is, of course, there's a gap between, and Ron's shaking his head, there's this gap between what the law says and what happens on the ground. And there are a couple of procedural problems for the lawyers. Number one, they don't use the system of precedent. They don't use the system of precedent. So if a judge does something incredibly smart or incredibly stupid and you want to argue from it, you can't. And then the other thing is, when you have the law being silent on an issue, the idea of arguing by analogy, you're basically arguing one case. You've seen one case, you've seen one case. So even though the law is written in a wonderful way that is very pro-media, it doesn't, in the short run, it doesn't seem to have the same impact on press freedom as we do here. So the third thing I want to mention is shield laws. And again, they're actually ahead. If you look at Brandsburg versus Hayes and you say, does our U.S. Supreme Court give us shield law protection regardless of what state you live in? Of course, it doesn't, right? But their constitution does. They have a shield law in the nation of Kosovo. We do not. Of course, the individual states can, and many, many do. And then finally, I mentioned before this whosarat.com, someone brought that site up. In Kosovo, if you disclose a confidential witness, they just prosecute you. It's a crime. So I'm going to run out of time here pretty quickly, but I want to tell you really in summary form what the journalists say about the judges and how I think if we can learn anything from this in this country, I think it may be the following. So journalists say the judges are autocratic and disrespectful to the press and their mission, that they refuse to help us get the story right. That's what Beth's point was. And then they complain when you get it wrong, that they don't follow the press law that's right there on its face, and that they sometimes make up their own press rules. There are these fungible rules that say you can close the courtroom in the best interests of justice. Well, guess what? Frequently, if the judge wants to close the courtroom, that's the reason. The final point in my 30 seconds, the judges over there, if you can get them in a room, and I don't mean a big room like this, but if you can get them hooked up like almost one-on-one, two-on-one, to talk about what to do when there's a problem, there seems to be a little glimmer of light, a little crack of hope. I have identified a couple of really progressive judges and a couple of really smart journalists who have some legal training and tried to get them together. And that seems to be something that might have some promise. Thank you.